Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we aim to update you on an ongoing project we are currently engaged in, followed by a call for your assistance. Stick with us until the end if you are interested in contributing to our mission of humanizing wrongful convictions. Hitting the thumb up below and subscribing to this channel also helps with this mission. Thank you. As emphasized in our video titled Spoken Injustice, We Have a Big Plan, linked in the description below, the true scale of wrongful convictions in England and Wales remains unknown. Our knowledge of wrongful convictions is largely based on cases overturned by the Court of Appeal, either directly or through referrals by the Criminal Cases Review Commission, or CCRC for short. These cases typically involve individuals whom we refer to as victims of the criminal justice system, spending years in prison, and where campaign groups have dedicated years to bringing these cases to the Court of Appeal for eventual redress. See, for example, the case of Mr. Markinson, which we have covered in several of our videos. However, our experience and conversations with numerous individuals claiming innocence revealed that the database of overturned convictions only captures a fraction of actual innocence claims. This is because, as we mentioned before, and as shocking as it may appear to those who are not legally trained, factual innocence is not a factor that the Court of Appeal is concerned with when reviewing convictions brought to its attention. In other words, you cannot appeal a conviction simply stating that the judge or the jury had made a mistake and you are, in fact, innocent. As we know, our criminal justice system's structure discourages revisiting criminal cases, prioritising finality over justice. This is evident when one considers factors such as prior permission required from the Court of Appeal in order to lodge an appeal, or limited appeal timeframes, currently 28 days from conviction, stringent requirements for new evidence, and narrow tests applied by the Court of Appeal and the CCRC. In the case of the Court of Appeal, we're talking about the safety test, which has been very restrictively applied, allowing appeals only whether there has been a serious unfairness in the conduct of the trial or a significant legal misdirection. And also we have looked at the limited test for referrals by the Criminal Cases Review Commission, namely the real possibility test, which encourages, as we have stated before, the CCRC to be too deferential to the Court of Appeal and to seek to second guess what the court might decide. Not to mention the fact that the juries do not give reasons for their decisions, rendering utterly challenging to appeal a verdict that is evidently inconsistent with the weight of the evidence, whether this was reached by a jury appropriately directed. We have investigated these issues and provided insights in two of our videos, Court of Appeal, Time to Reform the Law Machinery or its Operators, and the Law Commission and the Criminal Appeals Reform, which you can find linked in the description below. In particular, in relation to the Law Commission's project to reform criminal appeals, the Law Commission set the context by stating, in our comprehensive review, we will consider proposals for reform that will ensure the robust safeguard against wrongful convictions and instills confidence in the criminal justice system. This was in response to claims by various groups that the current system can make it too difficult for wrongfully convicted people to appeal where exculpatory evidence was available but not used at trial, and or to obtain and analyze evidence which might suggest a person's innocence. We know that numerous instances of wrongful convictions have not been actively pursued for correction. These may be attributed to the fact that these cases either involve smaller offences, resulting in fines or brief imprisonments, which fail to garner widespread interest, while the consequences remain deeply troubling for the affected individuals. They may not be deemed serious enough for the community or advocacy groups to show sufficient concern. Or alternatively, these are cases where exculpatory evidence is unavailable. For instance, in a rape case, DNA evidence may be employed to exonerate a wrongly convicted person. But in situations such as conspiracy cases, relying particularly on circumstantial evidence, for example, the challenge of mounting a defense becomes more complex. These individuals are let down twice, first by the criminal justice system, then by those who advocate for a fairer criminal justice system. This is where we seek your assistance. Have you, a family member, friend, or community member, been wrongfully convicted? Did you or they choose not to pursue an appeal due to a lack of grounds, or did an appeal prove unsuccessful? Then we want to hear from you. It does not matter whether your conviction was obtained in the magistrate's court or in the Crown Court, if it occurred a few decades ago or recently, if you were imprisoned as a result of it or not. The only relevant element for the purpose of our project is that you did not commit the offence for which you were convicted. We also encourage those involved in the administration of justice, such as defence solicitors and prison officers, etc., who come across such claims, to encourage those individuals to reach out for support. We are presently engaged in creating an interactive and extensive database specifically designed for these claims. This registry will undergo meticulous examination using suitable tools to initially establish the overall number of claims. Subsequently, our attention will be directed towards understanding why there was no pursuit of remedy, or why, in cases where recourse was sought, it proved ineffective. Establishing the total count of innocence claims will facilitate a comprehensive assessment of the scope of the issue. and discerning the reasons for unsuccessful resolution will enable the grouping of similar cases with shared causes, which will in turn offer insights into potential areas for reform and possible solutions. The database will also support a study on the psychological impact of wrongful convictions, addressed in our interview with Professor Greenberg of King's College, as well as in our video titled Moral Injuries. Both videos can be found linked in the description below. Finally, we are inviting collaboration from advocates, defense solicitors, psychiatrists, and other specialists in this field interested in joining forces for this crucial initiative. Here is that appeal again. If you have been convicted of a crime that you did not commit, or you know of someone who has, contact us via our networking hub at spokeninjustice.net. In there, you will be directed to fill in our Victim of Miscarriage of Justice form, which will be collated in our database. The appeal also goes to those in charge of administering justice who come into contact with someone who is unable to appeal either directly or indirectly to the Court of Appeal via the currently available routes, to encourage them to reach out and participate to this project. Finally, if you are an advocate, defense solicitor, psychiatrist, or other specialist in this field, please join our networking hub to express your interest in joining forces with us. I hope you found this video inspiring, and if so, please like it and subscribe to our channel to allow wider audience and to support us in our mission of humanizing wrongful convictions. Also, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again next week. We look forward to usher you as we sit and rise in this unique trial.